Your vote, CS or CSSB 1456, is reported favorably. Take up tab 6, SB 7068, on pretrial detention hearings by Appropriations Committee on Criminal and Civil Justice.
Thank you,
Bradley,
Mr.
you're
Chair.
recognized to explain the bill.
Oh, sorry. Thank you, Mr.
Sorry
Chair.
about that.
Members, hearsay testimony is currently allowed to be considered by the court in pretrial detention hearings. And in certain cases, hearsay evidence may be the sole basis for ordering pretrial detention. Those are cases that involve capital felonies and felonies punishable by life in what are called Arthur hearings. Last year, the court expanded certain provisions of pretrial detention, and SPB 7068 allows a court to similarly base an order of pretrial detention solely on hearsay testimony for the first-degree felonies that are listed as dangerous crimes in 907-041-5A. Of the 26 dangerous crimes enumerated in 5A, 20 of them would potentially rise to the level of a first-degree felony, depending on the specific facts. These include crimes like kidnapping, human trafficking, and child abuse, the worst of the worst. We're not talking about all first-degree felonies, only those listed in 5A. And for those felonies, the bill would allow a judge to base pretrial determinations, which happen within 5 days of arrest, solely upon hearsay. The judge would then be in the position to consider the credibility of the evidence and make the determination whether the individual can be released without putting the community at risk of physical harm. And lastly, just to clarify, the bill does not make any changes to what would happen at trial. This would solely be pretrial detention. And that's the bill, Mr. Chair.
Members, do we have any questions?
Yes, Mr. Chair.
Senator Powell.
Thank you. And Senator Bradley, I know we discussed this in our committee previously, but with regard to pretrial detention, you said the changes last year constituted the need to do this change this year, and the idea of changing the way that we look at hearsay, so you can use hearsay to meet a lower standard. What would be the difference of that and what we're looking at in the Arthur case, those Arthur hearings?
Senator Bradley.
Thank you, Mr. Chair. And to be clear, we're not in the bill that we passed last year. We did not lower a standard for first-degree felonies. The state would prove that beyond a reasonable doubt. What we're saying is that that standard can be met with solely hearsay evidence for those enumerated offenses.
Senator Powell.
Thank you. Thank you, Mr. Chair. Do you think that these changes being, I guess, to allow for someone to be held in pretrial based solely on hearsay would potentially increase jail populations? And I even have information here, would it potentially change potential outcomes because of pretrial? Many times people who've been held in pretrial detention are more likely to take a plea that they may have not taken had they had the opportunity not to be in
Yeah, thank you, Mr. Chair, and thank you for the question. And if you look at the crimes that we're talking about, again, it's not all first-degree felonies. We're talking about things like sexual battery, armed robbery, carjacking, offenses against children. And the change is so that in those cases, within 5 days of arrest, we don't have to bring the victim back to court to testify in person. That we're able to play the CPT video of the child's testimony, which has to be under oath, to be able to prove the pretrial detention, so we're not releasing these folks that are committing these heinous crimes back into the community after the judge considers that evidence. And so for those individuals, that was pursuant to the change we made last year. Yes, we don't want, if they commit these heinous crimes and the judge says no, they can't be back in the community without putting the community at risk of physical harm, then yes, they should be detained.
Senator Powell.
Thank you. Thank you, Mr. Chair. As a follow-up to that, we had one state attorney say that they were bringing people within 5 days, having to get people out of hospitals to testify. And also, I think there was some verification that may have not been completely accurate. But the question I also have is, when using testimony, maybe even of a child in his hearsay, could there be instances or cases where one parent or guardian or someone has maybe coerced the child to say something that may not be 100% accurate, and now you've potentially got someone in pretrial detention position based on hearsay, and there's not been an opportunity to really verify that information. Is that a possibility if we change this language today?
Senator Bradley.
Thank you, Mr. Chair. And as I said previously, allowing pretrial detention determinations to be based solely on hearsay currently exists for other categories of cases. The judge is in a position to determine that credibility. The defense is certainly able to present their evidence, and there's nothing that limits it to solely or says that it has to only be solely. The state is certainly in a position to offer direct evidence if that exists without further traumatizing the victim.
Thank you. Thank you, Madam Chair.
Any other questions? Yes, Senator Book.
Thank you so much, Mr. Chair. Senator Bradley, is this really a procedural question more appropriately left to the Supreme Court or the Florida Bar to handle?
Senator Bradley.
Thank you, Mr. Chair. And I think when you deal with evidentiary questions, it's a little murkier, especially the evidence code, what's procedural and what's substantive, and a lot of times they intertwine, and that's the reason why we have a state evidence code. We make those decisions, and burdens of proof and privileges. Those are things that are appropriately substantive in nature, and especially when it advances a public policy goal. And that's what this bill does. It prevents us from further traumatizing victims.
It's certainly, that is a world that I understand far too well. And I just, under section 907.041, subsection 2, Senator Pizzo, where it reads that procedures for pretrial release determinations shall be governed by rules adopted by the Supreme Court. In addition to separation of power concerns, aren't we contradicting our own legislation in making this change?
Bradley.
Thank you, Mr. Chair. And that would be for solely procedural. And I don't believe that this would be a solely procedural. I think this evidentiary change would implicate public policy. And Article 5 also gives the legislature the final say on these questions, because it allows the legislature to veto or repeal the rules put in place by the Florida Supreme Court. So I think the legislature on these matters of public policy appropriately have the first word and the last word.
Senator Book. Any other questions? Senator Pizzo.
Good morning. Thank you, Mr. Chair. Senator Bradley, even though we are shifting to a change to allow for hearsay only, can the judge ask for more?
Bradley.
Thank you, Mr. Chair. That's the prerogative of the judge to determine the credibility of the evidence. This rule would allow it to be based solely on hearsay.
Yes, Senator Pizzo.
Good boy.
If the judge said,
Come here, Mac.
I understand, state, that you can rely entirely on hearsay, but I want more.
Stay. Sit.
Bradley.
Thank you, Mr. Chair.
I know that
And
some people in the audience would be kind of, we could phone a friend, but
Sure, and at the end of the day, the burden has to be met by the state. The burden has to prove beyond a reasonable doubt that there was the commission of the crime and that the individual can't be released safely back into the community.
okay, I want to be there. If I can follow up. Thank you, sister. Just for the record, even though going forward, presumptively, this passes, signed into law, and you may rely entirely on hearsay after this passes, a judge may still require more evidence to satisfy their need for the underlying crime and the threat that that defendant poses to society to detain them, even though within the four corners of what passes says that they can rely on hearsay only.
Bradley.
Thank you, Mr. Chair. The judge is in the position to determine whether or not the state has met their burden of proof. And this allows the judge to make that determination solely on hearsay.